Hey friends, Casey Ashmore coming to you from the studio. Today we're talking about all things protective order. I know it's a heavy subject and I'm passionate about it, and one of the reasons that I was drawn into prosecuting and defending family law cases is because, if you come from a family violence household, extended family violence household, you see a lot of stuff that shouldn't happen to little children, to mommies and daddies, and it's got to stop. It's got to stop. And that's what our legislature has, that's why we've been voting for people for 30 years to put these protections in place. So there's ways to stop this kind of abuse. So things that, we're talking about, that 14-day window from when the ex parte order is signed and the hearing. Cut a deal, right? Make an agreement if possible. Avoid final rulings. Avoid findings where there's merit regarding the abuse, regarding the allegations of family violence, and avoid long-term repercussions, which we have no idea we have no idea what those are going to look like. You're going to be prevented from going on a skiing trip in Iceland one day because of some family violence. You're going to be prevented from renting an Airbnb one day because some finding in family violence. As the world gets more and more informational, the ability to keep things quiet, right? That's the whole purpose of the transparency of our judicial system. And whether that's going to affect an employment situation, renting a hotel, condo, what have you situation, getting into certain countries that are very, very strict about who they'll accept and who's inadmissible, right? And just this is a risk. Maybe there's a way to avoid it. Compromises that way. The thing about family violence hearings, temporary hearings, is that I was talking in the prior segment, a lot of it can be like a surprise attack because you don't have to disclose all the witnesses and evidence that's coming against you. They have 20, sometimes the judge will be more generous and give them longer, sometimes 40 minutes, right? Especially when it's a really serious case, really serious allegations, and sometimes you'll only have 20 minutes. And so in 20 minutes, which seems like a long time, but it's really not. And think about how fast 20 minutes goes in in any high pressure situation, right? When you're watching your favorite sports team, that 20-minute quarter, what have you, whatever it is, it seems to go quick. And there's not going to be a whole lot of timeouts, right? There's not going to be replay. It's going to 20 minutes. So you got to be aware, and then also be aware that outcries that children make, whether they be to law enforcement, to counselors, what have you, their outcries are coming in. So these are things that you may be aware of because you're the person seeking the protective order. You may not be aware of because you're the person defending against the protective order. And you got to be ready for that. You got to anticipate that, and they're coming in, right? Recordings of their statements, notes regarding what the child said. These things are going to come in. They're going to be part of the hearing, and they're going to be part of the court's determination as to whether a protective order should issue. And those protective orders they can look like a whole lot of things, but the most dangerous thing about them is they can be good for 2 years, which means complete exclusion from your children, right, for 2 years because of the past abuse. Depends on how serious, right? But many times they include a lot of immediate protections, some immediate supervised time, if there's going to be time at all with the kids. It's going to be monitored, heavily monitored, and then there's going to be some sort of thorough background checks, psychological evaluations, and other things that are going to have to happen so that the court is satisfied and other experts can report to the court as to the situation, the merits of the case before a final order is entered regarding the allegations of abuse. So a lot of things can happen at that temporary orders hearing. My experience is nobody really comes out the winner on that one, because a lot of times those draconian impositions like psychological evaluations, home studies, attorneys ad litem, those drive up the costs. And they may be there. They may absolutely need to be there. But here's another thing, takeaway. Do not file a counter. I do not recommend. I've never seen a counter motion for emergency protection. One, the court can only grant one request for emergency restraint protection, right? And it can only be against one spouse against the other. Can't grant two against. So whatever that notion is, that I'm just going to go, I'm going to be louder. I'm going to be angrier. I'm going to come back harder. I've never seen that work. Most experts would tell you don't do that. And that's my opinion. Don't do that. It's best to defend as fiercely as you need to, as opposed to bringing one of your own. And I think it's like an automatic signal to the court that yours isn't meritorious because it's the responsive request. And if something came up later, that's a different story. But when we're talking about responding to the first one in that first 14-day window, I wouldn't recommend doing that. Anyway, I hope you're never in these situations. I hope if you are, that this video series is helpful, informative, instructive. Please like, subscribe, and share. I think I have one more coming from the studio on protective orders. I know it's a heavy subject. Thanks for being a part of my team and allowing me to be part of your team.